We are here this morning to report to you the results of our joint investigation into how AggregateIQ, a company based in Victoria, British Columbia, Canada, collected and used the personal information of voters in a number of jurisdictions, and whether it took the appropriate and necessary steps to protect the personal information of those voters. While some of these campaigns took place in foreign jurisdictions where AIQ may have been subject to those laws, they and every other Canadian company doing work abroad still remain subject to the privacy laws in this country. While we found some of AIQ's services were covered by the consent of individuals, in many other instances, they were not. This included micro-targeted online profiling using social media, which was clearly not based on consent. They were gathering from clients' Facebook data, which they were uploading to Facebook for analytic purposes and for what are called custom audiences. In our view, that would not be within the expectation of British Columbians who would have given that information to those parties. And to that extent, they in fact were not in compliance with British Columbia privacy laws. And AIQ's response to the collection of that data, and did they collect it lawfully, they said, well, there's basically no law that exists in the United States by which their clients obtain that information. To which we say as regulators, well, you operate here in British Columbia and in Canada, and regardless of what's going on down in the US, you have an obligation to ensure that that data was collected with consent. So it was from ethnicity to race to voting, voting intentions in past elections, obviously pretty sensitive information. And what we need to do, and this investigation I think demonstrates it, is that we need to have tougher regulations to ensure that Canadians, the public, voters have trust and confidence in their political campaigning system at the heart of our democracy.